Hey, good morning, everybody. I gotta tell you, I'm a little emotional this morning. Could this be the last day of YSL? It very well could be. Let's see who we've got tapped in here. Caustic Chameleon, Paramount Angel. I know I butcher your name. Sue Lily, Law and Above, uh, Captain Paw, Karen A. Taylor Mayberry, um, Ian Dog. Good morning. Good morning. I see they're on the seal right now. I seen they were in there just a few minutes ago, and I was getting everything set up. But yeah, what do y'all think? Could this be the last day of YSL? If they have a quick deliberation, it very well could be. And I got to tell you, I'm a little bit in my feels about it. A little bit. But this is not the last of our little slime family here. We're we're moving on to other things. There's always trials, there's always shenanigans going on. There's always things going down. Hey Grace, hey Kim, hey Sharvie, come on in. As soon as they come back, we'll jump over there. Um, and I'm going to get y'all's opinion of what you want to do when they go back to start deliberation. Do y'all want to just stay live and stay on a verdict watch, or do you want to go off air and just come back when they come back? Don't just let me know in the chat what you want to do, and we'll do whatever you want to do. We can watch YSL clips and takes and things like that if you want to for a couple hours and see if they come back with a quick verdict. Hey, press or pray and press. Stay on verdict watch. Polish the instructions. Yeah, that's why I didn't really go live with it because I just thought that would kind of be boring. So one person says stay on verdict watch. Anybody else have an opinion? Oh yeah, we're gonna watch. We're definitely gonna keep up with them. Hey Q, but we're not gonna watch it like this. I don't think. It's gonna take the rest of the day to read the jury instructions. I know it's gonna take probably an hour or 2, but you think it's gonna take the rest of the day? Like verdict watch? Verdict watch could take hours, yeah. It could, yeah. Okay. Well, we'll fill it out and see what time it is, when they get done reading the jury instructions, because it definitely, this is why I sell everything takes longer than expected. That's very true. That is very true. Now I've never done, uh, verdict watch when they were doing a RICO case, um, so I don't know how long jury instructions will take for a RICO case. I assumed it would just be an hour or 2 like a regular case, but I could totally be off. That's a good idea, Captain Papa. Let me do that. That is a great idea. Look how smart you are. Okay. I'm still guessing about 8 hours. That's my guess, but All right, my YouTube has been acting a darn fool today. It's not giving me the option to. Oh man. There we go. How long does the jury take for a verdict? All right. There should be a new poll up. No, they have not. They're getting their instructions here in just about 5 or 10 minutes. Good morning, Matthew. Good morning, Toker. Oh, nobody's going for the under an hour. See, y'all were talking a big game yesterday. Oh, they're going to be quick. They're going to be 30 minutes. They're going to be, yeah, it's different today. Look, y'all told me to wait till after Christmas to break out or to after Thanksgiving to break out my Christmas stuff. I couldn't do it. I couldn't do it. I got my snowmans on today. I couldn't wait. Y'all, I kept thinking about Doug calling them out on the red, saying, some would say the prosecution's a gang. I was like, oh gosh, that was beautiful, Doug. That was beautiful. Because they're all wearing red. Some would say they were a gang for other reasons. It was great. It was a moment to behold. That was great. It was fantastic. Let's go ahead and pull in the seal here. There it is. There we go. We're signed, sealed, delivered. And I'd be darned if Hilton didn't scream through that whole thing. She screamed through that whole thing. Like, aren't you supposed to make them like you? Who's gonna like somebody that screams at them? She screamed through that whole tag thing, and I finished listening to it, but she screamed through the whole. She's unhinged, yeah. I can't believe she screamed through all of it. I think she's worked up because she knows that they're not doing very well, and I think she let it show. It's 11 o'clock, and the camera's moving. Are they going to start exactly on time? No, of course not. Oh no, I'm going to make a bet on this. I bet you they're wearing all different colors today. I bet you they don't come in matching today. because they got called out for being a gang yesterday. I bet you they don't come in matching today. Oh, they're not? Oh, it's no, it's already said. She does not have on a pleather suit, stop. She does stop. And dog, stop. She does not have on that a Temu suit, stop, quit. Don't. She does not, quit. Stop. Oh my gosh. Okay. I see you, Hilton. I see you where you live. Okay. All right, let's not talk about how look, I started that. Let's not talk about how people look. She's beautiful in God's eyes. I just don't think pleather should exist at all. It's like styrofoam. It's just shouldn't be real. No, you're good, Toker. You're good. Maybe for Club Crucial. Is Club Crucial still open? Is it still a thing? Because they've gotten some bad publicity through this. We'll see. Club Crucial. It is temporarily closed. It doesn't say why it's temporarily closed. It just says it's temporarily closed. Hmm. It's rated 2.5 out of 5 stars. Sounds like a classy joint. So this isn't going to be like real gripping and riveting like yesterday was. Um, like I gotta admit, I was hung on to every word yesterday. It was good. You could have not watched the whole case and been sucked in yesterday. I thought it was very, very good yesterday. Um, Probably the best day of the case so far, um, on both sides. Um, but today's just going to be telling the jury how they're to come about getting their verdict. Um, I'm going to tell you, they already know how they're going to, and I could be completely off base, but they already know how they're gonna come back. Good morning, Shannon. Hey, Debbie. I mean, like they're sitting there, they already know if they're coming back guilty or not guilty on most of those counts. If you were a juror, you would know too. I mean, if you ever served jury duty before, you knew before you walked back there. Hey, Caged. The last thing I heard before they went to seal was the judge saying she had to go back to her office and get something off her computer. So I know she's not really technical. So it's probably taken a few minutes. Yes. Yes. If they decide to retry them, they could decide not to retry. I doubt that will happen, but they could decide to not retry. Let these boys go to the house. I don't think it helped. No, I think she thought it was helping. It ain't always like this, Q. It's not always like this. I served on a jury where a guy robbed a bank, and he did it for health insurance. Isn't that sad? He did it for the insurance because he had an illness and he didn't have insurance. And he literally went in there with a note that said, uh, I'm robbing you for $1. And I have a gun. It did say and I have a gun, which he didn't. And yeah, he wanted to go to jail, and he went to jail. Oh, Yvette, you know they are. And good morning, by the way. Being called but never went. I don't know how you got away with that, Toger. I want to know if we're going to find out where the missing jewelry is before this trial's over, or if we're just going to have to figure it out on YouTube or TikTok or whatever, because that's really frustrating. Y'all, my nerves are bad. I'm my nerves are shot over this. Like I got one leg bouncing up and down. I don't know if y'all can see me jumping. Served on one last year. Sheriff accused of SA. Ooh. Oh, I see, Q. I was nervous when I found out what kind of case mine was, but it was so straightforward and simple. Dude was a creep. Really. And see, that's so sad. It shouldn't be that way. Oh, we need to take care of our elderly and our widows and our disabled. A civil suit. Yeah. Yeah. I think that's probably usually the way it is. See movement in the court or somebody bumped the camera. You never been called. And see that I hadn't been called until I was like 35 years old, which was just last year. No, I'm just kidding. I don't know what you guys are doing for Thanksgiving, but I'm gonna try to stream on my channel, Miss Mandy Reacts, all day or most of the day for people that are alone, or if you're just in between meals or whatever you're doing. If you want to come over there and hang out, I'm going to have an open panel so you can come up and hang out, and we're going to watch different videos and try to show funny stuff all day long and just kind of laugh and have a good time and just hang out. So if you want to come over and hang out and not be alone, because I know what that's like. So just come over and hang out if you want to. Try to do that on Christmas too. Do be another guy with a tire crossbar. Oh my gosh. Ooh. Yeah, I look forward to having you, Shannon. We're just gonna have a watch a lot of Fail Army and just have a good time. I love Fail Army. I'm a big kid though, Q. Okay, I see Paige's head. All right, here we go.
Okay.
On Thanksgiving Day in Dog, which is Thursday.
Your Honor, we've located some authority on main cases, United States versus Elliott 571, F2nd 880, it's a former Fifth Circuit case. Elliott dealt specifically with the question where the defendant argued that acquittal on a RICO substantive required acquittal on a RICO conspiracy. And the court said no, it did not.
Yeah, that's not.
It's an often, it draws the distinction. But that being said, we are looking at the changes that were just forwarded to us, and think that there, for the vast majority of these, there may be a pretty simple, direct workaround that addresses the issues we're talking about.
Okay. Well, I'm not sure we need to decide it before the jury charges anyway, so. All right. Anything else then? Otherwise, I'm gonna have the jury out and go ahead and charge them. All right, let's get the jury out.
Hey, Paige, I'm going to need you to turn the microphone back on. Paige. Judge Whitaker.
Violation of the Georgia Controlled Substances Act. 61, possession of a firearm during the commission of a felony. And 63, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Mr. Stillwell has been indicted for counts 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. 2 and 49 are counts of murder. 50, participation in criminal street gang activity pursuant to subsection 1 of that statute. 51, participation in criminal street gang activity pursuant to subsection B of that statute. 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during your deliberations. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, the instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is the doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If after considering the evidence, you believe beyond a reasonable doubt that a defendant is guilty of an offense alleged in the indictment, you would be authorized to convict the defendant of that offense. If the state fails to prove the defendant's guilt of an offense beyond a reasonable doubt, it would be your duty to acquit the defendant of that offense. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses, the exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, and these 4 stipulations are marked as joint exhibits. Where parties stipulate facts, that is in the nature of evidence, You must take that fact or those facts as a given without the necessity of any further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Direct evidence is is that which can be seen or heard or otherwise directly sensed. It may be brought into court in the form of exhibits or the testimony of a person who asserts that he or she has actual knowledge of a fact by personally observing or otherwise witnessing that fact. It is evidence that points immediately to the issue in question. When direct evidence points by inference to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly observed or otherwise sensed, that's said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that tends to prove or disprove another fact by inference, that is, with consistency with such a fact or elimination of other facts, or that only tends to establish a conclusion in question by its consistency with such conclusion or its elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence alone, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or a greater degree of certainty on the part of you, the jury, to return a verdict based on circumstantial evidence than upon direct evidence. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. And whether it's dependent upon direct or circumstantial evidence or both, the true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility, and this may include evidence of a character for untruthfulness, bias toward a party, or felony criminal convictions. In determining the credibility of any witness whose credibility has been attacked or challenged, as I've described above, and any testimony given by him or her in court, you may consider, where it's applicable, evidence offered to support the credibility or believability of such a witness. The credibility of a witness may also be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony that the same witness gave before the trial started. It's for you to decide whether there's a reasonable explanation for any inconsistency in a witness's pretrial statements or testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if that is shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of all of the witnesses. The testimony of a single witness, if believed, is generally sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. An exception to this rule is made where the witness is an accomplice. The testimony of an accomplice on its own is not sufficient to warrant a conviction. An accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It's not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does in fact support the testimony of another accomplice is a matter for you to decide. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose or against some parties and not others, or for some counts and not others. I have previously instructed you as to how to consider particular evidence that was limited over the course of this trial. Such evidence may be considered by you only for the sole issue or purpose, or against only the party, or only for the counts for which that evidence was limited, and not for any other purpose or against any other defendant or for any other counts. You have received evidence of certain prior convictions of these defendants as well as certain other witnesses in this case. You may consider the conviction of Mr. Kendrick only against Mr. Kendrick and only as to count 1 and as to the required element of being a convicted felon in count 63. You may consider the convictions of Mr. Stillwell only against Mr. Stillwell and only as to count 1 and as to the required element of being a convicted felon in counts 52 and 64. You may consider the convictions of any witnesses only insofar as they may relate to attacking the credibility of that witness and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out of court or any out of court identification. It's for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict on those counts. If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor. You are not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of a crime, unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer Influence and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy. For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you, because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of codeine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act, as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity. For malice murder, the state must prove that a defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation, and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have, to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes any handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony, or of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon when you get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols or THC. The state must prove that the defendant possessed the marijuana and or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending upon which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant knowingly possessed the marijuana or the firearm. And I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that, for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person's property from the immediate presence of the other person by using an offensive weapon and with the intent to commit theft. An offensive weapon is an object that's either likely to cause or actually does cause death or serious bodily injury if it's used against someone. Conspiracy to commit murder. A person commits conspiracy to commit murder when that person conspires with one or more others to commit the crime of murder. Murder has been previously defined. Criminal attempt. A person commits criminal attempt to commit a crime when, with the intent to commit that crime, the person performs any act that constitutes a substantial step towards the commission of the crime. Criminal gang activity has been previously defined. Criminal use, a person of an article with an altered identification mark. A person commits the offense of criminal use of an article with an altered identification mark when he possesses a firearm from which he knows that the manufacturer's serial number or any other distinguishing number or identification mark has been removed for the purpose of concealing or destroying the identity of that article. Possession of a firearm by a convicted felon has been previously defined, but in addition, with regard to that offense, possession of MDMA with intent to distribute, possession of cocaine, and robbery are felonies. Possession of a firearm by a first offender probationer. For possession of a firearm by a first offender probationer, the state must prove that the alleged perpetrator possessed a firearm while on probation for a felony as a first offender. Robbery and criminal damage to property are felonies. Possession of a firearm during the commission of a felony has been previously defined, but in addition, for these overt acts, possession of codeine with intent to distribute and possession of cocaine are felonies. Possession of a machine gun. The state must prove that the alleged perpetrator possessed a machine gun during the commission of any of the following offenses: participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. A machine gun means any weapon which shoots or is designed to shoot automatically more than 6 shots without manual reloading by a single function of the trigger. Possession of controlled substances. For possession of cocaine or oxycodone, the state must prove that the alleged perpetrator possessed any amount of cocaine or oxycodone, both of which are controlled substances. Possession with intent to distribute. For possession with intent to distribute codeine, hydrocodone, marijuana, MDMA, or methamphetamine, the state must prove that the alleged perpetrator possessed any amount of marijuana or any amount of codeine, hydrocodone, MDMA, or methamphetamine, which are controlled substances, with intent to distribute. And intent to distribute means intent to unlawfully deliver or sell. Sale of marijuana. For sale of marijuana, the state must prove that the alleged perpetrator sold any amount of marijuana, and sell here means to transfer marijuana in exchange for money or anything else of value. Possession of a weapon by an inmate. For possession of a weapon by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized weapon. For possession of a telecommunication device by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized cell phone. Conspiracy to possess a telecommunication device by an inmate. A person commits conspiracy to possess an unauthorized telecommunication device by an inmate when that person conspires with one or more others to commit the crime of possession of a telecommunication device by an inmate. For terroristic threats, the state must prove that the alleged perpetrator threatened to commit a crime of violence and that the threat was made. Theft by receiving stolen property. A person commits theft by receiving stolen property when that person receives or keeps stolen property and the person knows or should have known was stolen, unless the property was kept or received with the intent to restore it to the owner. Knowledge on the part of the alleged perpetrator that the property was stolen, or evidence sufficient to show beyond a reasonable doubt that the alleged perpetrator had reason to know the property was stolen, is an essential element of this offense. Knowledge that the property was stolen may be shown by circumstances that would excite suspicion in the mind of an ordinary person. The burden is on the state to prove beyond a reasonable doubt that the alleged perpetrator had knowledge, or under all the circumstances should have had knowledge, that the property in question was stolen and was in the alleged perpetrator's possession. All right, that's it for the overt act crimes. All right, the law provides that criminal action shall be indicted and tried in the county in which the crime was committed. In a prosecution in any case in which it can't be determined that what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt it might have been committed. We don't have that here, do we? So essentially just the state must prove that the criminal actions alleged as counts in this case, that they have to be tried and indicted and tried in the county in which the crime was committed. So venue, that is that the crime was committed in a particular county, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue may be proven by direct or circumstantial evidence or both. To prove venue for the RICO count, the crime is considered to have been committed in any county in which an incident of racketeering occurred or in which an interest or control of an enterprise or personal property was acquired or maintained. The defendants are each charged with certain offenses that are set forth in various counts of the indictment. Each count is a separate and distinct offense, and you must independently evaluate the evidence against each defendant and as to each offense. The fact that you reach a conclusion with respect to one offense or with respect to one defendant does not necessarily mean that the same conclusion will apply to any other charged offense or to another defendant. Each count of the indictment before you is separate and distinct. You must evaluate evidence as to one count independently from evidence of each other count. You must evaluate the evidence as to each defendant independently, and you must render a verdict as to each count and as to each defendant individually. If, after considering the testimony and the evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant in Fulton County, Georgia, committed an offense as alleged in the indictment, you would be authorized to find the defendant guilty of that offense. In that event, the form of your verdict for that offense would be to find the defendant guilty. If you do not believe the defendant is guilty of an offense as alleged in the indictment, or if you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense. In that event, the form of your verdict for that offense would be to find the defendant not guilty. You are to make a separate determination of guilty or not guilty as to each offense and as to each defendant. Your verdict as to each count must be unanimous. That means that you must be unanimous in your determination that the state has proven every element of that count as defined and listed above beyond a reasonable doubt. And you'll have a copy of these instructions out with you so that you can see what each of the elements of each of the offenses is. Again, the elements are listed above where the crimes are defined, and you must be unanimous that each element has been proven. Let me explain what that means for a few of the elements for count one a bit more specifically. And that's the conspiracy to violate the RICO Act. You must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. But because count one is charged as a conspiracy to violate the RICO Act, it's not required that the state prove that any conspirator actually committed an act of racketeering activity. And on the overt act element, you must be unanimous that a conspirator committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. And you would note on your verdict form that and any of other overt act committed in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against any party. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it's wrong. However, you should never give up an honest opinion simply to be congenial or to reach a verdict solely because of the opinion of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. And these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. During your deliberations, any communications from you to the court must be in writing, signed and dated by the foreperson, and given to a bailiff. And let me add that given that the evidence is closed, my ability to respond to questions may be limited. Evidence that was admitted by audio or video recording can only be played here in the courtroom, so any request to view or listen to that evidence again must be made in writing by you to the court, and then it'll be replayed in the courtroom. And that is the end of my instructions. I'm going to excuse you all to the jury room now to elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, and 508 to hang back with me. And the rest of you can return to the jury room to elect your foreperson.
All rise for the jury.
Wow, less than an hour. Wow. So fast. It's time. It is 12:10 Eastern time. Oh, we're definitely doing verdict watch.
All right, y'all are the alternates in the case. Considering the length of this trial, it was critical that we had alternate jurors in
poor
case we
alternates.
lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take. And so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty. You're not going to be deliberating right now.
I feel so bad for these
but
people.
you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at any kind of social media or any other kind of accounts of this trial or
They're coming
anybody
home and
involved
getting in
in the
chat.
trial. Essentially, you're still on jury duty. I am going to, for the next hour or so, keep y'all around here. And
She expects a fast
Sergeant,
verdict.
maybe, I don't know, I'm sure there's probably another jury room that they can retire to. While y'all are on jury duty and the jury is deliberating, I want y'all to stay within an hour or so of this courthouse.
She expects a
If we're
very
ever on
fast
break,
verdict.
you know, we've got Thanksgiving break coming up. Obviously, y'all can go and do whatever your Thanksgiving break plans were because the jury's not going to be in session, court's not going to be in session, we're not going to be deliberating. But even when you're on those breaks and any others that might occur during the deliberation process, you still can't talk to anybody about the case or allow anybody else to talk to you about the case or look for any information in any way about the case. So essentially you remain on the same instructions. Just when we're on break, you're on break too. When the jury is deliberating, I need y'all to be where if we need you, we can get you within an hour, down here within an hour or so, okay? So for right now, y'all can go and grab your things. You can say goodbye, it's been great. I may see you again to your fellow jurors. And then we'll have you in one of the other jury rooms for a little while at least. And if I'm going to release y'all for the day, I'll let y'all know that. But again, just kind of stay within an hour or so of the courtroom. And just like you've sort of kept your cell phones in a way that we can communicate with you, continue to do that in case we need to. Thank you very much.
Oh my gosh. Can you imagine going through this for 2 years and then being told you're an alternate. Your opinion doesn't matter. You don't get to decide their guilt or innocence. Can you imagine?
Are there objections to the chart?
Oh my gosh. Can you imagine being told you're one of those
Okay.
people? Can you try to put
On
yourself in their
page
shoes?
2? Okay.
When reading participation in criminal street gang activity for count 50, you said subsection 1 and not A. So I just wanted to
Hang
make
on
sure.
a second. Let me get there. Page. Where are you talking about?
So count 50, where it has participated in criminal street gang,
Yes.
you said section 1 and not A.
Okay. Do you want me to call them all back in and say I meant to say A, or they'll have copies of this out there and it'll be on the verdict form correctly?
Yes, Your Honor.
All right.
That's fine. I didn't know if I had something different than what you had, and so I wanted to make sure that what I have in front of me.
No, don't call them back in.
Okay.
That'll be great for mistrial.
Only as to page number 9, when you, last paragraph, any out-of-court statement,
Hang on.
They will get the forms
Yes.
probably about
as we were reading it, the thought
5 or
came
10
that
minutes.
maybe we should add any out-of-court statement made to law enforcement, made to the police, made by one of the defendants on trial in this case after.
And then we will be on jury watch.
We probably should have.
So just,
I gave y'all this, I don't know how many different times to look at and ask you. I don't know how many different times for any kind of comments or corrections. So what do you want me to do?
can we add it, and then when you send it back?
Y'all, my nerves.
That's
I'm
all, Your Honor. I'm just-
scratching. My nerves are bad.
Made by one of the defendants, made to law enforcement by one of the defendants on trial.
Let them do it.
Okay, we can do that.
Be perfect for an appeal.
And as of right now, those are the only ones that I see.
All right, appreciate it. Thank you. Anybody else?
I have no objections to your reading of the jury charges, Your Honor. I just need to renew my request and objection to exclusion of jury charge 3.01.10, which is the
Show
justification,
short. What are you doing?
as I requested justification for my client's possession of firearm by a convicted felon. I requested that charge, so I'm just renewing my objection to the exclusion of that charge, as well as the separate and distinct charge that overt acts need to be proved. An overt act needs to be agreed upon unanimously by all the jurors. I know Your Honor stance that you referenced the need for unanimity, being unanimous. I always
Mhm.
struggle with that word.
Okay,
Within the jury charges, and I understand that, but I'm just going to renew my objection.
okay.
Thank you.
All right. Then we will, y'all have agreed as to what evidence goes out?
Well, he just made an objection, so no, not really.
Yes, Your Honor, there is we're including a flash drive with a list of the exhibits, the Stillwell exhibits.
Okay.
And I thought it would be appropriate, and if it's not appropriate, please object. It's just a list of the exhibit numbers, because the flash drive is little, so we can't list them all. So we're printing on a piece of paper,
Okay,
and we're just going to attach the flash drive to the piece of paper.
okay. And those don't go out. You're just saying you're listing them.
Let's
My
be nice. in
understanding, well,
chat,
they
please.
can't play them. My
Right.
understanding is that all the media was going to go in the back room. They can't play it, but then they could ask if they wanted us.
Just so they'll have a list of what it is?
I'm not even proposing the list of what it is, as in what each exhibit is, but just that these are the exhibits that are on this flash drive. I'm not suggesting,
We don't normally send the actual media out with them.
Okay,
I mean,
we
they
had
can,
this-
it's certainly in evidence and they certainly can consider it. They just would need to say, hey, I'd like to watch the FedEx tape again.
Okay, my understanding, and I had spoken to some members of the state about this. The understanding I had was that the media was going to go out, but of course they have no way to play it, but then they could request.
Okay, are they gonna even, if it all, for instance, goes out in a bin, are they gonna even know what it is? Like, are they all labeled? Yes? I mean, it's fine with me if that's the way y'all want to do it.
The only other thing we were going to ask to do, I believe the Feds Council has an objection. We were going to send a legend out with the letters and what letter is associated with what act, so that they would know.
What
We
letters?
organized
I
them.
don't know what you mean by that.
So every act that we presented, so for example, VV was the Chamel Drinks homicide, so that they can know when they pick up a letter, what that was in reference to.
I'm going to object to that, to the state's kind of direction of compartmentalizing the evidence. And quite honestly, some of the evidence that was admitted under certain letters applies to certain other cases. I mean, these aren't distinct. I know that they're charged as distinct over acts, but Walter Murphy testifies, for
Right.
instance, and he has things they admitted to Walter Murphy might have a WW, just for instance, but what he testified to involved different acts.
I mean, I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53 WW, then they can find that. Or if it's media, they can ask to re-listen or replay it. I don't think that it's really appropriate to say, here's kind of the state schematic of the evidence. Okay. So have y'all otherwise agreed on what evidence goes out with them and what evidence doesn't?
So I've been presented some case law this morning and we've discussed it. I don't have any problem with the GBI reports going back. I know that was one bone of contention. I don't have any problem with the ME reports going back. We've been going back and forth about two issues, the CAD reports and the
Okay.
demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay. You wanna?
I join in.
Okay.
Mr. Sharp, yeah.
All right. Does the state feel that the CAD reports or the demonstratives should go out?
Yes, Your Honor, we have case law regarding demonstrative evidence
Okay.
that demonstrative evidence does go back to the jury, and it's not a violation of the continuing witness rule.
Would you like to share that with the court?
Yes, Your Honor.
Okay.
This state will cite Ruffin v. State, which is 333 Georgia Appeal 793, which is a 2015 case.
Mm-hmm. Okay. And then how about the CAD reports? What's the objection to the CAD reports? Okay. And does the state have a position on that?
Your Honor, the state does not believe that the CAD reports are a violation of the continuing witness rule, and we are looking, I thought we had the case on point, but we are looking for that case as well.
I know, right? She needs to figure out what she's doing here.
Okay.
I have a case, Your Honor, it's a March 2021 case. I'm going to spell it Pattarozzi, state 385 Georgia Appeal 675. It stands for basically what the continuing witness rule applies to, and capital court would not be something that is listed as something that wouldn't go back because it would be a continuing witness because it's an original evidentiary document and it's non-custodial in its nature.
Does it cover CAD reports at all, or is it just kind of, here's what continuing witness means?
It's just kind of just here's what continuing witness means. I couldn't find a case specific or on point as it relates just.
It's hard to believe, honestly. You know?
Which leads me to the conclusion they go back.
Yeah. So does the defense have any case law on CAD reports? So I'm looking at a case, Muse, from the Supreme Court from last year, 316 Georgia 639, and it also doesn't cover CAD reports specifically, but it's talking about surveillance videos. And it says, here the surveillance videos were not the reduction to writing of an oral statement, nor a written statement provided in lieu of testimony. And a CAD report, I mean, it contains the reduction to writing of an oral statement, doesn't it? So it may be that it can go out redacted.
But have you hit the like button yet?
What does CAD stand for? Computer aided.
Dispatch.
Yes, Doug talked about it. He said it would be several $100,000.
Mm-hmm.
I wanted to share this in case it helps. My thinking is with the arguments we've had on CAD reports,
and 911 calls.
Mhm.
In our, many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redacted. And so my understanding with the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony. In terms of that non-testimonial analysis is part of the genesis of the continuing witness rule. But, and
Mm.
that was why I wanted to share that. And this is coming from, I believe it's the same case that Mr. Abadi cited, the PATTA. But I just wanted to share that because it just hit me that that pre-analysis, of course, with the CAD and 911 specifically, we have argued and the court has ruled on that part. That was all I wanted to share, Your Honor.
There's another case that's pretty new, Davis v. State, just 371, Florida Appeals 469, 2024 case.
I mean, in the Catarazi or whatever it is case, the continuing witness rule is inapplicable where the documented issue is original documentary evidence or where it's non-testimonial because it's not a reduction of or substitute for oral statements or testimony. It's certainly not a substitute for oral statements or testimony. And it is original documentary evidence. And I think we already redacted out of every CAD report, at least since I've been involved, any hearsay, right?
Your Honor, it is true, what Mr. Atkins said, to my recollection, is completely accurate, as we did have a series, when we went through these CAD reports, a series of hearsay objections and confrontation clause objections,
Right.
and some were redacted.
Yeah. All right, so then I think it would be my conclusion that it is all right for them to go out as long as they're all redacted to cover the evidentiary rulings that I made previously, or that the predecessor court made previously. All right, did y'all, I hadn't had a chance to look at the demonstrative law yet. Yes.
So they have no way to play media. Why send media out redacted? Can someone explain that to me? If they have no way to play media, why send it out at all? I don't get Shark's fight on this. Normally, I'm right there with them, like
All
we're
right.
here, but
My reading of reference is that demonstratives can go out with the jury. Y'all, if y'all got something contrary to that.
Let me just be clear what demonstratives we're talking about. 'Cause
Uh-huh.
they all-
Mhm.
I believe there's some physical evidence that Ms. Weaver may have in her,
She's got guns and drugs.
for the drugs.
Neither of those is going out to the jury.
Okay.
If you have pictures of them, those can go out. Or you suggest, is there anything besides guns and drugs that she has?
So we're gonna look at the
Okay.
evidence list.
Y'all aren't suggesting that either of those go out with the jury, are you?
No, we're talking, we have the jewelry upstairs. and,
Okay.
I mean, some of that may or may not.
Not sure we want that to go out with the jury either, considering the allegations in this case by one of the attorneys. Unless we've got an armed guard in there.
We're gonna go over the exhibit list, trying to see what else Ms. Weaver may have.
Y'all got pictures of the jewelry and pictures of the guns and the drugs, right?
Yes.
Okay. And those are those in evidence?
Some of the picture of the jewelry.
Okay.
While that's being done,
Mhm.
I have permission to just step out for a moment.
Sure, absolutely. Yep.
Thank you.
There seems to be pretty um,
Excuse me, Your Honor.
yes.
Regarding Ruffin v. State, having looked at the demonstratives the state plan would like to send back to the jury, these are demonstratives that were, if not all, at least for the most part, I think all, produced by the state for use with their witnesses. Whereas
Okay.
in Ruffin, that was an anatomical chart apparently used. Well, actually, I can't tell if that was, it looks like it was used by a medical examiner in the parenthetical.
So I'm looking at, it's a fairly old case from the late 90s, but it says items of demonstrative evidence. It's Gabbard versus State. Hang on. Let me find that part.
Oh, Gabbard v. State,
Yeah.
Your Honor,
Mm-hmm.
233 Georgia App 122.
Yes.
Let me pull that up.
These were also anatomical drawings to illustrate victims' testimony.
There's a more recent case, more v. State, Georgia Supreme Court case 311, Georgia 506. It addresses demonstratives as well as the cell
Sorry, was that Moore v. State?
Yes.
Thank you.
311 Georgia.
Thank you, Mr. Abate. This case, Your Honor, I think it seems to imply that the lead detective is the one that prepared the PowerPoint summary that went out to the jury, not a demonstrative prepared by the state. Unless I'm reading it quickly, but it appears to be a distinction there.
Okay, so I'm looking at the case McKenzie versus State, 300 Georgia App 469. It says the continuing witness rule does not apply to demonstrative evidence designed to illustrate testimony given by witnesses. Here, the documents complained of were designed by an investigator it was the DeKalb County DA's office based on other admitted exhibits, including cell phone records, dates and times that checks were cashed. The documents were admitted at trial and served only to summarize the other admissible evidence. There was no violation of the continuing witness rule. I mean, that was more like a summary document, but I guess that was demonstrative and summary. And it was prepared not by the witness, but by one of the parties, and it was not subject continuing witness. Seems okay to me.
I'm going to have more of a challenge distinguishing that one, Your Honor.
All right.
Yeah, I don't know.
So I think unless y'all come up with something else, that I'm going to overrule the objection to both the CADA reports as described, redacted, and demonstratives going out. Other,
There are some pieces of physical evidence, Your Honor, hats,
okay,
other clothing items
yeah,
that we're having someone go to retrieve to bring them down.
okay,
And I think by the time we retrieve that, gather everything, we'll be ready to
all right.
collect everything and have it sent back.
One other matter, there are two demonstratives that were admitted by Mr. Steele.
Okay.
These were admitted at some point during the trial.
So I'm,
In January.
yeah,
I don't-
those are just blow-ups of
Yeah.
the language of certain
Yes, Your Honor.
overt acts.
It was admitted when Trontavia Stevens was on the stand. I don't particularly have a strong feeling one way or another about them going back. I'm not sure.
I'm thinking those aren't needed because they're going to have the indictment itself out, and that's really just a magnification of certain of those items on the indictment. So we won't send those out. And if y'all want to look through whatever other demonstratives there are, that might be a good idea. I feel like I asked y'all to do this several times, several weeks ago.
They just went through it, I
Hmm.
believe, Mr. Atkins.
All right. Okay. Well, good. Thank you. So I keep. Hmm? Can you do that? Yes.
You know,
Hmm.
the state has used demonstratives which were the result of their writing during testimony.
Right.
I don't believe that those are covered under the case law that we're talking about. This is just literally writing in trial. I don't think that makes it a demonstrative. Essentially, they were writing to encourage the jurors to write. Is kind of the way I saw it. Sending a message, write this down because it's important. But I don't believe it's appropriate for these to go back.
Thoughts? I mean, it didn't seem like that was being used to help the witness illustrate their testimony. It was more to help the jury kind of. Okay, so those will not go out.
So I'm gonna put these right here with the, not those.
Okay. All right, y'all can continue to do this. Let's take a quick recess though. And y'all do that during the recess and then maybe we'll come back and once it's settled, okay?
Is there a ballpark for this reset?
Honestly, it could be our recess / lunch if you want it to be. So you want to come back at 1:30?
Yes.
All right, see y'all at 1:30.
Thank you.
You've got to be joking with me. That they don't have this done, that they didn't have this done before they read the instructions to the jury. I'm ready for Daddy Donald to fix this crap. That's hilarious. That's hilarious. But really? They didn't have this finished? I mean, Paige, like, oh, I feel like I asked y'all to do this already. That's the instruction you gave them? I mean, I'm not trying to act overly outraged, but Paige, I was really impressed with you with how you handled Thug and all that, but I'm not feeling the impression today. I'm not feeling it today. Okay. All right. Well, she got through the instructions really quick. That was a lot faster than I thought. I've seen instructions last hours, so that was pretty quick. But I know, and dog, I am, but I'm looking at it this way too. This leaves some opening for a mistrial too. So try to think of it like that. So we are not on a verdict watch. We are on a hold while they take a break. While they get documents and look through demonstratives evidence, while they look through evidence. So, no, it's not okay. So what's going on is they are deciding what evidence goes back with the jury and what doesn't, which is something they should have done beforehand. So they're just waiting. They're not on a verdict watch or anything like that. They're just waiting. They were deciding if they were going to redact anything, but she overruled that and decided not to do that. So, yeah, it's kind of, yeah, Greg's pretty much dead on. Oh, yeah. Oh, yeah, it definitely is. It definitely is. This should have been done. They should have decided already what was going back with them before they even read the jury instructions, man. Before they read the jury instructions. I can't. The sleeves door is wide open. Some more Brady? Jason, you mean some more Brady? They already shoved some Brady in there. You mean they're going to put some more Brady in there? Here, take some more Brady. Y'all, I got to have a sip of drink because they got my nerves tore up. My eyes keep watering. Y'all, they got me tore up today. Lord, be with these jurors, please. Let your will be done in these men's lives. Look, this is an emotional thing. Sorry. Well, let's watch this video that I pulled up. It looks really good. It's the 10 wildest moments in the Young Thug trial. It's called The Circus. Maybe it'll get our minds off of things for a little bit. I'll keep the seal up in the background for when they come back, and we'll go right to court, okay? Let's get our mind off of things for a while.
Michelle, free bug, Michelle. Aren't you interested in removing the cloud that's hanging over the case right
Whoa,
now?
what did I, wait.
Free bug, Michelle, free bug, Michelle. Aren't you interested
What was that? I don't even know what that
in
was.
removing the cloud that's hanging over the case right now, Your Honor? If you bring
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court.
I'm so high right now, y'all. I'm about to go to sleep on y'all now.
There has been no shortage of incredibly outrageous moments in the criminal trial of rapper Young Thug, so let's do a full breakdown of some of the most wild incidents over the last 18 months. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Hey everybody, this is a Law and Crime legal alert. Google Incognito tracked users' browsing data without their knowledge. Yep, well, Mass Tort Alliance, one of our legal sponsors, is helping users file for compensation due to Google users' privacy issues surrounding Google Incognito. So if you've used Google Incognito anytime since 2016, you can start your claim in less than 10 questions at incognitoclaims.com/sidebar. It has been quite a ride so far on the Young Thug trial out of Atlanta, Georgia, hasn't it? When you think about the last 18 months or so, we have seen some absolutely wild, unforgettable moments that I'll tell you right now, I don't recall seeing in other trials. I really haven't. And that's not me saying it lightly. I cover trials all the time. Now, this, of course, is the case of rapper Young Thug, whose real name is Jeffrey Lamar Williams. He and his co-defendants, they were indicted on a laundry list of charges, including the main underlying charge, conspiracy to violate the state's RICO or racketeering law, namely that they agreed to illegally obtain property and money through a pattern of criminal activity in furtherance of a criminal enterprise or gang known as YSL, or Young Slime Life, as alleged by prosecutors. And when we talk about conspiracy, there has to be an agreement to break the law, and there has to be overt acts or steps that are taken in furtherance of that agreement. Now, overt acts, they don't necessarily have to be crimes. They just have to be certain actions that were taken. And the idea here is that Williams and others had an agreement to participate in gang activities.
He's got a handsome smile, doesn't he?
And there were 191 overt acts taken in furtherance of this YSL gang. So no wonder this trial is taking quite some time in order for the prosecution to prove all that. Now, more than 24 other men were charged as well in connection with this case, but that number has dwindled down by the time we got to the start of trial. That was for various reasons. Their cases were severed. They took plea deals. Now, the defense is suggesting that YSL is merely a record label and that there is no gang or criminal enterprise or association here. So we have dedicated a lot of sidebars to what has been happening in this case, but now we're going to aggregate it all together. This is going to be a full compilation of some of the most wild moments in this trial, and we're going to start from the beginning with what happened in jury selection. Now, let me preface this by saying that as we do this recap, the judge presiding over this case, Judge Earl Glanville, runs a no-nonsense courtroom. You break his rules, you step out of line, he will punish you for it, okay? To give you an example, 2 jurors learned that the hard way. So one prospective juror improperly recorded the jury selection process proceedings on her phone, and Judge Glanville had her arrested.
Why shouldn't I hold you in willful contempt?
Okay, so I'm going to explain everything that happened that day on the 17th of March.
Okay, but before then, do you recall this court giving you the ad nauseum admonitions about acceptable behavior?
About having phones out.
Yes.
At the moment when we came in,
Didn't I tell you to turn your phone off?
it was, I'm going to be truthfully and very honest. When it was a lot going on, we had just come from different
Answer my
floors.
question first, and then you can explain it. Do you recall us telling you to turn off your cell phones?
Yes, sir.
Okay, do you also recall me going through a litany of different things that would cause us to potentially put the case in jeopardy? Do you remember me saying that to you?
I mean, I couldn't hear. It was so much people. It was so many people talking and so many people doing different things. So
people were talking when I was giving that admonition to you?
yes.
Meaning that you didn't hear it? You didn't
Yes.
hear any of the 10 minutes that I went through on the record about the things you couldn't do? Specifically, you couldn't research on Google. You couldn't go ahead and otherwise contact your friends on social media. Do you remember that?
Well, I remember the part when you saying we had to, but I didn't hear the turn off the phone.
You
until the
remember
middle
me
of the
talking
speech.
about no social media?
Yes.
Do you remember me also pointing to the placards that are on the wall about social media and the things you cannot do?
And I didn't see that until after the fact.
You don't recall me pointing that out to you?
No, sir.
I tell it multiple times for multiple reasons, and you decide you're going to just do what you wanted to do.
It's not
Pull out your phone.
doing what I wanted to do. I just
Well, you pulled out your phone and videotaped our proceedings, and that was in direct violation of this court's order. So I'm going to sentence you to 3 days of in jail, and that will otherwise satisfy your contempt.
But it was so much going on. I suffered.
That doesn't excuse your behavior, and it doesn't give you.
I didn't hear every.
Madam, that does not excuse your behavior, and it doesn't provide it's an excuse for behavior.
It's a big deal. It's a big deal recording the jury selection process because it endangers the defendant's right to a fair and impartial jury. And Judge Glanville explained that a punishment, like a sentence here of 3 days in jail, we do that for a variety of reasons: to deter her and others from doing this, rehabilitation, reentry into society, retribution. Now, while Judge Glanville sentenced her to 3 days in jail, she was actually released 5 hours later. And I would wager to say that she probably learned her lesson throughout all that. Then we had another prospective juror who apparently didn't return for jury duty during the jury selection process. No, instead, she apparently went on a trip to the Dominican Republic. Now, that might sound bad on its face, but let's provide a little bit of context here. We'll hear how it played out, because she explains that she didn't see the jury duty notice until late, and then she had this trip. And you will hear Judge Glanville's decision, which was something.
Actually, just receiving the jury summons. I travel a lot. I've always traveled a lot globally for work and other things. But I traveled. I wasn't here Thanksgiving week, the week of the 28th. So, and I don't think I returned until like the 16th. I was in the UK. And because I live with my grandmother, I didn't go because I was exposed to travel, didn't want to make her sick. So I don't think I actually saw the summons until like the 30th. And
The 30th of December?
Yes. And I also know I had these medical appointments. I have 5 weeks of scheduled infusions for the next 5 weeks, starting the 20th upon my return. But they said send an email, and I did the first thing the next morning. I also called aggressively trying to get through. And that voicemail I called, I checked yesterday, it still says if you have an issue, send it with your jury summons, send an email, and you will not be penalized or something. So I sent that. I didn't really know I was in violation until the sheriff showed up.
You know, there are a lot of people that were inconvenienced. I mean, severely inconvenienced. You're not the only person that outlaid money. I examined people yesterday who lost literally hundreds of thousands of dollars trying to be here, and I have to make decisions in regards to that. But I didn't even get a chance to examine you about your circumstance, because you went to, you said, okay, I'm going to go. What I think I'm going to do is, in order for you to satisfy your contempt, I'm going to commute the 20 days and require you to write a 30-page paper on the importance of jury service. Here's the criteria. You'll have to do APA style. You're going to have to use at least 10 primary sources, 10 secondary sources.
30-page paper. I told you, I've never seen anything like that. That is a punishment. Yeah. Now, Judge Glanville said she shouldn't have just left. She should have figured out a way to bring this to the court's attention so that they could work it out. Now, I imagine she and anyone else who might be serving on a jury in Judge Glanville's courtroom or other courtrooms might be thinking twice. But I should tell you, it wasn't just jurors getting in trouble. No. How about when someone allegedly smuggled marijuana to one of Young Thug's co-defendants in a pair of shoes? Or when another co-defendant's mother was arrested for trying to sneak tobacco products and rolling papers in a bag of clothes? Or when another contraband incident ended up halting the jury selection process for an entire day? Here's what Judge Glanville had to say about it at one point.
We've had yet another instance of alleged contraband being introduced to our space. And as a result of that and a subsequent investigation, one of our inmates unfortunately had to go to Grady Hospital. The other thing I would just invite counsel to talk with their clients about, I know I've mentioned this 3 times now, what is considered to be acceptable behavior. This is the 3rd time that we've had contraband introduced into this in this space. The court's concern is that this may pose issues to them remaining and being present in this space.
And in one of the more memorable moments, one of Williams' co-defendants, Khalif Adams, was allegedly seen on camera walking up to Young Thug and handing him something. Now, prosecutors say that it was a Percocet, which is a brand of oxycodone. And to his credit, Young Thug immediately handed the pill to law enforcement. Adams was taken to a holding area where his attorney alleges that Fulton County deputies searched him, but also tased and assaulted him. Adams ended up going to the hospital. Adams is already, by the way, serving a life sentence for murder, charged with conspiracy and attempted murder in this case. But given what happened in court, he was also hit with drug possession and obstruction charges. But it wasn't just jurors held in contempt of court or defendants getting in trouble with the court or family members or friends of defendants. No, it was also attorneys. Yes. So defense attorney Anastasios Menendez represented defendant Miles Farley. And one day it was reported that Menendez was undergoing a routine check of his bag when he was coming into court, and officers found a bottle of prescription medication and arrested him. As officers closed in on Menendez, he allegedly went to toss his phone to another attorney, but apparently it hit one of the deputies. So he was charged with simple battery on a law enforcement officer and possession of pills not in their original container and disrupting courtroom proceedings. Menendez got his own attorney who said that the battery charge was dropped. Menendez was released from the Fulton County Jail on $5,000 bond. But that wasn't the only time Mr. Menendez had been in trouble with the court. He had been held in contempt another time. Now, the reason not entirely clear, but what we do know is that he was ordered to pay a fine of $250 and buy all of his colleagues lunch. Very unique punishments put forward by Judge Glanville. So at one point, the judge wanted to know if Mr. Menendez had actually bought lunch.
You were held in contempt, young man. And if you want to revisit that again, we can certainly open it up. But I satisfied your contempt by you paying $250, which you did, and I have a receipt from that of your choosing, which that was done to Miles College. I have that receipt here. And the other thing was to purchase lunch for each of your attorney colleagues in this case on Friday, March the 17th from Jason's Deli. So prong 1's been settled. Prong 2 was you're supposed to buy your colleagues lunch by that date. Mr. Menendez, this was in satisfaction of me not sentencing you to jail for 20 days. So if that's the case, well, then I will revisit the basis for your contempt. But I thought that, and in fact, I'll have Ms. Weaver go ahead and pull that order, pull the part of the record. But I did, in fact, I did not hold you in, I did not go ahead and sentence you to the 20 days. I said that this would satisfy, once you apologized, I said, you can pay, because remember, you were going to do I was going to have you do a report as well, or a written product. I was also gonna, but instead of doing that, we settled on the $250 and we settled on your buying lunch for your colleagues on the 17th of March. So that was my understanding.
Yeah, my understanding was that I apologized and that I was doing that to sort of show that I was serious on the apology. I'll still buy the lunch.
And that will satisfy this court's concern, okay?
And it doesn't end there. No, of course, there was recently when Young Thug's lawyer, Brian Steele, got in trouble. He was held in contempt of court. And this was a very, very controversial move and drew the ire from many in the legal community. So Brian Steele had become aware that an apparent private meeting took place between Judge Glanville, prosecutors, and a key witness named Kenneth Copeland. It's called an ex parte meeting. It's in the judge's chambers. Defense counsel was not alerted of this meeting. They were clearly not present for this meeting. And Steele took issue with this because he claimed that his client should have been privy to this, especially since Copeland, who is going to potentially testify about Williams' involvement in the murder of Donovan Thomas, was allegedly threatened by prosecutors and the judge in order to testify, and claimed that he would testify that he was responsible for Thomas's murder, that he wouldn't tell the truth while on the stand. So very important information that allegedly happened behind closed doors. Well, Judge Glanville didn't seem to focus so much on the content of the meeting as much as he was upset about how Brian Steele found out about it. So Brian Steele complains about this meeting, and then let's hear what happens.
And then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. What I was told was that Mr. Copeland said,
and you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why did
Sir, I'm going to hold you in contempt if you don't tell me who this. Tell me who this information
was. I don't want to
come
be
from.
held in contempt. Well, I'm not answering that question. That's attorney-client privilege information.
So the judge called for a 5-minute recess, and when he came back, he still demanded to know how Brian Steele had learned about this private meeting in his chambers and what was said. And this is where it gets complicated, because it seems Steele is saying, you're giving me an impossible choice here, Judge. If I tell you, I violate the ethics rules. And if I don't tell you, I'm going to be held in contempt of court.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not. I'm
The
trying to
issue
reach you.
is, how did you get this information?
I understand the issue. I
Who
promise you I
told you?
understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot
Rule
you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you.
Okay,
you're
but
saying,
see,
you're threatening me with
the
contempt. Just
privilege
listen
would
to this.
occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not some substance, but I'm telling you, I can't do that under the bar rules.
All right. Well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have
may
an
be
idea
wrong.
how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Okay, Steele said he couldn't reveal his source of the information. Glanville said he could, ended up holding Brian Steele in contempt of court. Ordered him to spend 20 days in jail, that's 10 weekends, and actually agreed that he would share a cell with his client, Mr. Williams. But the Georgia Supreme Court stepped in. They paused imposition of the sentence while the appeal of that contempt plays out, so Brian Steele will not be reporting to jail. It is being reported that it seems the judge believes he figured out who relayed that information to Mr. Steele, because the judge seemingly doubled down and ordered a show cause hearing to be held with Mr. Copeland, Copeland's stand-in attorney, Kayla Bumpus, as well as prosecutors, everyone that was at that ex parte hearing or that meeting. And again, it seems based on the words and the language that he used that he believes Ms. Bumpus was the one who relayed that information to Mr. Steele. So they all have to show cause why he shouldn't hold one or more of them in contempt for sharing information about the ex parte meeting that's set for June 25th. But the fallout from all this didn't end there. No, another defense attorney, Doug Weinstein, tried to have Glanville removed from the case, and it got tense.
You can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings.
You're always talking about how the appellate court.
No, because if I grant the certificate, it stops the case, okay?
I don't agree with
And I'm not going to do
I
that.
don't believe it stops the case.
I'm not going to do that.
And if
You can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you bring
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. I just, as a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you.
Now, in case you didn't hear that, Weinstein said to Glanville, the judge, that wasn't he interested in recusing himself to remove the cloud over this case? Wow. And look, it's an interesting question because essentially Glanville is a witness in this case. The argument is he should allow a separate hearing to be held on the contempt issue because he's accused of holding this allegedly improper meeting and intimidating Copeland. That's the allegation. That's the argument. Anyway, moving away from that. This was also not the only interesting back and forth between the judge and Brian Steele. No, when an officer took the stand to talk about stopping Young Thug in a car and allegedly finding a stolen gun in the vehicle, Steele holds the weapon in court in a way that Judge Glanville wasn't too happy about.
Through your work, you find out that this item from running a computer check comes up stolen from the serial number. Is that how it works?
Yes.
Okay. And you found the item, though, underneath the passenger seat on the floorboard. Is that right?
I need to teach you about handling weapons. Please point the muzzle always downward, no matter if it's unloaded, okay?
I know it's unloaded, but yes,
You
sir.
make everybody nervous, okay? To include Mr. Kearns, who you're pointing it at. All right.
I apologize, Mr. Kearns.
Now, I don't want you to think that the judge just had it out for the defense. No, the judge also had issues with the prosecution, too, that made for some very wild moments, like this back and forth with prosecutor Adrian Love. So the issue here concerned Mr. Weinstein, again, talking about him. He's representing Diamante Kendrick, and he wanted to suppress a 2015 police interrogation video of Kendrick because he claimed that the investigators violated his client's rights by asking him more questions after he had asked for a lawyer. We know that, 101. You ask for a lawyer, the questioning stops. Well, the judge watched the police interview outside the presence of the jury, and he was wrestling with the issue when there was this interaction between prosecutor Adrian Love and defense counsel, and even the bailiff had to get involved.
The thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Where it specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or until the suspect reinitiates the conversation.
Your Honor, at some point, Your Honor,
I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop. Your Honor. I was speaking.
Ms. Love, y'all got.
I'm sorry, I was speaking.
Both y'all can't talk at the same time.
I know, I was speaking, and I expect to be allowed to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
I know you're being an advocate, but at some point, stop.
Look, this is a serious issue, right? When a suspect, a defendant, asks to speak to counsel, the questioning stops. And anything that is gathered after that may not be able to be used in an upcoming trial. Now, during the course of this trial so far, there's been a lot of back and forth between Love and Judge Glanville. And again, makes for these very memorable moments.
Given that we have witnesses on this list, like Detective James Thorpe, who is at the Atlanta Police Department every day, and
You told me that yesterday. And what did I tell you?
Your Honor,
What did I tell you yesterday? I'm not going back through this, Ms. Love.
I'm not asking that.
Monday the 4th, we'll look at a hard list for the court's consideration. And is there anything else at this point in time?
Your Honor, did juror number 39?
Would you stay out of my business, Ms. Love?
Oh, well.
Stay out of my business.
Judge,
Look,
I'm sorry.
I've been doing this a long time. Yes, yes. And if you really must know, she's going to reschedule her appointment to the week of the King holiday. You happy? No, you're not happy. But anyways, that's the explanation you're going to get. I'm on top of it. Okay.
Yeah, something to say the least. Now, look, when I think back on the past 18 months of this trial, there are so many moments. Like, how about when somebody over Zoom interrupted the proceedings?
Free fuck, mistrial. Free fuck, mistrial.
Or when the judge admonished someone in the courtroom in the middle of testimony.
Excuse me, Miss Love. Madam in the black, get rid of your gum. Remove yourself from my courtroom and get rid of your gum. In the earrings, you, get rid of your gum.
But I'll tell you, some of the most wild, memorable moments have come from witnesses, like Adrian Bean, who prosecutors were hoping would tie Williams to criminal activity. But he didn't seem to really want to be there, and he seemed to admit something quite interesting on the stand.
All this going on right here got me up on this stand, talking about this and that third, all this extra stuff that's going on, Your Honor. Am I on trial, Your Honor?
Sir, you just have to answer the questions unfortunately at this point in time, okay? That's all I can tell you.
Am I on trial?
No, sir, you are not on trial, but you have been properly summoned here as a witness and you're subject to examination until I release you.
I never consent to do none of this, sir. I ain't signed nothing. My name ain't on nothing. They come get me. Y'all don't threaten to lock me up. Hey, I got a family too.
You just heard that you explained that you qualified it as the detectives and police. And I asked you the authorities, the police, the prosecutors, I just made it broad, that they forced Jeffrey Williams into it. Did you hear you say that?
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Yes, you may. You can take a break.
Yep. Then let's go back to Kenneth Copeland, aka Little Woody. He had some interesting moments as well.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Well, are you gonna let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
By the way, what's interesting about doing that is, let alone pleading the fifth to that question, was that the fact that he was granted use immunity in this case, meaning his testimony can't be used against him by state prosecutors, so he can't necessarily invoke that privilege anymore. There is an issue legally if what he says could be used by federal authorities. But look, at the end of the day, he was held in contempt of court for not participating. But remember, the prosecution needs to tie Williams to the 2015 shooting death of Donovan Thomas, aka Big Nut, an alleged rival gang member. Shannon Stillwell and DeMonte Kendrick, two of Williams' co-defendants, they have been charged in connection with the shooting, and Williams himself is accused of renting the car that was used in that alleged drive-by shooting. Now, the prosecution needed Copeland to confirm that he knew these men allegedly involved in the Thomas hit, but even that was difficult.
Tell me if you recognize individual in State's Exhibit 350 Yankee.
I recognize myself.
Okay. Do you recognize anybody else in 350 Yankee?
Myself.
Do you recognize anyone else in 350 Yankee?
Their face is covered up.
Okay. Do you see someone's face who's not covered up in 350 Yankee?
Yeah.
Okay. Do you recognize who that person is?
I can hardly tell.
Okay. Is that Shannon Jackson? Your Honor, at this point in time, I'm turning to impeachment. Do you know someone by the name of Demekion Garlington?
Street name.
Little D.
For sure.
How do you know Little D?
I didn't birth him.
I'm sorry, say that again.
I almost birthed him.
You almost birthed him?
Yeah.
Tell the jury, what do you mean by that?
I mean, he my son.
Okay. And let me ask you this. Do you know another person who's referenced as Little D?
What you mean?
Do you know someone who's called Little D from Cleveland?
Oh, I heard of him.
You heard of him. Okay, we'll talk about him in a moment.
You said what now?
Tell me who you recognize in 380 Yankee.
Oh, me and Coco.
Who's Coco?
The ugly boy right here.
Okay.
Let me give you a little background to this as well. So Copeland, he was seen speaking with police in an interrogation tape that leaked online. He was supposed to be the star witness or a star witness for the prosecution because he had previously told investigators that Williams was connected to criminal activity. But Copeland said he just said what he had to say to get out of trouble. And as he explains this, he even gets, of all people, the court reporter involved.
Did Thug ever speak with you about his relationship with Nut?
No.
Did you ever observe Thug and Nut together?
I never saw those two together. I never been around those two together. No, it never crossed my mind.
So how were you able to tell Detective Gaither that Nut and Thug was cool?
Because they're questioning me and I'm trying to get them off of me. And she asked me questions about Nut and Thug, I guess. And I'm telling her whatever she asked me, let's say she asked me a question about the sky. I'm gonna say, yeah, I seen the sky. It's blue. Whatever she asked me, I'm gonna agree to that. I'm gonna say whatever she asked me. If she asked me about this reporter right here, I'm gonna say, yep, she's sitting outside me with white tennis shoes on. I'm gonna say something. Just because I want her to believe I'm telling the truth. That I want her to get me out of jail.
What, she has on white tennis shoes, don't she?
Don't you got on white tennis shoes? She got on Chucks.
Right, and they white, right?
What color your shoes is? Okay. She got on Chucks.
So you telling the truth.
What color your shoes is? She said they white.
Right, so you're telling the truth then.
Well, it depends.
Also, I got to call this out. Do you remember when I said that Kenneth Copeland was in that ex parte meeting with the judge and prosecutors being represented by Kayla Bumpus at the time? She was standing in for his regular attorney who had gone out of town. Well, as I said, the allegation has surfaced, and based on Judge Glanville's statements in court, it seems to suggest that Bumpus may have been the one who told Brian Steele, Williams' attorney, about the ex parte meeting and caused this whole mess. Now, she and Copeland, as I said, will have to appear at a show cause hearing in a couple of weeks to determine if they should be held in contempt. But after all of this chaos surrounding the ex parte meeting, Copeland decided he didn't want her to represent him anymore.
Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay.
And according to Ms. Bumpus, she had already been fired even before Copeland had testified. But there was another witness I want to talk about. And this witness is identified as A.B. She apparently didn't come to court at first, defying a subpoena that she says she never received. This witness was allegedly the victim of an armed robbery in 2013, reportedly involving Williams, which seems to not be part of the indictment. But Prosecutor Love told Judge Glanville that she had spoken with the witness several times about the court needing to hear her testimony and said that the witness indicated she did not want to come to court. So she ended up telling Love that she was in the hospital, couldn't come in, but the DA's office says officers found her at home and actually arrested her on a material witness warrant. But if the prosecution then expected her to be particularly cooperative once she was on the witness stand or to give some bombshell incriminating testimony, they were wrong.
Do you recall telling the police that you turned your back on them to walk into the kitchen to make your baby a bottle?
No.
Do you recall telling the police that when you went to the kitchen, Thug's brother put a silver 9mm to the back of your head?
No. And my baby didn't even drink bottles. My baby was breastfed. So no.
Did you tell the police that the two suspects, that Thug, his brother, and DK demanded money from you and your gun?
No.
Now, here's where it gets even more interesting, because AB was cross-examined by Keith Adams, another member of Williams' defense team. And one of the areas of focus was that she was allegedly hit on by an investigator in this case.
Mr. Hamilton had contacted you prior to yesterday. Is that right?
Yes.
Mr. Hamilton had harassed you. Is that correct?
Yes.
In fact, you told us when you were back there that you didn't want to come out and see him because he had sexually harassed you. True?
Yes.
He wanted to meet you, supposedly to talk about the case.
Yes.
But now, how about the next one? That same night, Wednesday, February 7th, 6:45 p.m., where he says, hit me up if you're bored later. We're not going to talk shop. Remember that text message?
Yes.
Did you talk to him later on?
Yes.
Did y'all talk shop?
Yes.
What do you want to talk about?
Going out.
Going out? Going out as in walking out the door or going out on a date?
A date.
And this is February 7th of 2024, this year. when the investigator for the DA's office is supposed to be talking to you about a case, but in fact is calling you, talking to you about going out on a date. Is that true?
Yes.
Yikes. This case, am I right? Now I'm going to end it here with the testimony of Trontavious Stevens, the apparent co-founder of YSL, former co-defendant in this case who took a plea deal. And as we've seen during the course of this trial, you wonder how credible a lot of these witnesses are, whether or not they're not so forthcoming with information. And one of the most memorable moments was him struggling with the understanding of the word snitch. And at one point, prosecutor Adrian Love brought up the idea of snitching. And Stevens didn't really seem to know what she was talking about.
What does snitching mean to you?
It doesn't mean anything to me, but I'm aware of the term.
How are you aware of the term?
I've heard the term.
How do you understand the term to be used?
I'm not aware of the term to be used. Yeah, indicating that a person is a law enforcement or something. Indicating that a person is law enforcement or some nature.
So are you able to use snitching in a sentence?
Yes.
Please use it the way you understand it to be properly used in a sentence.
I heard someone is a snitch.
And please explain how in that sentence, snitch refers to law enforcement.
I can't.
Why did you use it that way?
I mean, I've seen movies, and that's the direction that the movie was going in. Maybe even used the term. Maybe even got it from like movies. Yeah.
And the way you understand the term, is it a good thing or a bad thing to be known as a snitch?
I really don't fully understand the term.
Now, as I was going through all this and compiling this script, there's a lot more. Okay, but we didn't want this episode to be like 9 hours long, which, by the way, very well could have been. But I'll tell you what, we are not even close to this trial being done. And I am sure the moments will keep on coming. So for right now, that's all we have for you right now here on Sidebar. Thank you so much for joining us. As always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.
That one was pretty good. There was a lot of stuff in there I hadn't seen before. Like the juror filming the jury selection process. He straight up put her in jail, which, I mean, they take the jury process very seriously. Like that's a very selective, serious, sacred even process. So I get it. I get it. I think they said they let her out after like 6 hours or something like that. So yeah. There was one name that kept coming up over and over again. I'm not gonna say which one it was, but I'm just gonna say one name kept coming up. Y'all were right in the chat, I think, about who told Steele that information. They are still out. I think they went ahead and went to lunch. I think is what happened. Let's bring in the seal. Yeah, I think they went to lunch. I think that's what happened. Other people say they are on verdict watch. That's what other channels are saying, that they're on verdict watch. They didn't say to us that they officially got the jury the information. That wasn't the name I was thinking, Indog, but we can go with that. So here's what we're going to do. We're going to, because they'll come back from lunch and then they'll start deliberating. So I'm gonna end the stream, and we will we'll put up a timer in Discord. Okay, so if you're a member, make sure you're in Discord. If you're not in Discord and you're a member, please go to the community tab. There's a link for you to get into the Discord. I'm going to set up a timer in there so we can time the deliberation process. Okay, and we'll see who is the closest guessing on the deliberation. And yeah, I know they haven't even picked a foreman. I'm with you. Very odd how they do things in Georgia. You peaches are odd. All right, so I'm gonna wrap it up. But listen, watch your notifications. Make sure your bell is turned up, turned all the way on. Okay, because as soon as we get a verdict, DWC is going to go live immediately. Okay. Okay. So have your bell turned on. Make sure your notifications are on. Mods, please make sure you can jump in immediately, because you're going to want to know. You're going to want to know. This is definitely a high impact trial. So we're going to want to know, right? Like, my nerves are shot. I know y'all's has to be too. Be prayed up, right? Be prayed up. Be prayed up. Should we wait the hour? Like, they've been on break for 50 minutes. Should we wait 10 more minutes and see if they come back at the hour mark? They were supposed to be at lunch till 1:30. Were they? Well, let's wait. Let's wait a few minutes then. Let's wait a few minutes. Because if I end it and then they come back, I'm going to be really upset. Let's wait a few minutes. Because I see heads moving around in the courtroom, and if they come back, they're coming back right now.
On here, that'll work for that. We've got copies of the redacted indictment to go out. We do not. We still have to sort out the language of those last couple of overt acts that we highlighted earlier. So can we figure that out? And do we otherwise have all of the evidence that's going to go out?
There was a chat during the lunch break to get into Judge Randall's chambers.
The deputies can get into anybody's chambers.
They just got it maybe about 5 or 7 minutes ago.
Okay.
They're getting the evidence, the extra chain of custody form, so they're trying to get a chain of custody form.
Okay, well, I mean, it goes from one court reporter to another, so do you want the court reporter to just walk up there and take possession of the evidence?
Yes.
That's probably the best way to do it. Then we don't need a chain of custody form. It just is with the court reporter. Yes, we'll do that. All right, so we will recess for our delightful new court reporter to do that. Thank you, Ms. Taylor.
Are you kidding me? Scrambling and scraping. Scraping and scrambling. Yep, they are still sorting. So they are not on verdict watch at all. They have not gone out to start deliberating. Oh my goodness. So they're going to get a piece of evidence. Yeah, they're on recess to get a piece of evidence. Okay. Yeah, they haven't even picked the foreman. You're absolutely right about that. So this is just scrambling and scraping. So yeah, I'm going to go back to what I was originally going to do. I'm going to go ahead and end, and we'll go on verdict watch. As soon as a verdict comes in, I will go live immediately, or Jason, one of us, will go live immediately. Please have your bell notifications turned on, and I will put a timer in Discord. Okay, everybody? There's no point in us just sitting here watching scrambling and scraping, but I'll let you know as soon as there is a verdict. Okay, I'll be watching and listening to every second. Okay, all right, guys. Grace and peace. Be prayed up. Be praying for these guys. Their lives are literally hanging at the bottom of this rope. Okay, bye, guys.
Hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian.